Hadrami.
My lords, my lady, I will make submissions on our primary case, which is that there is no need for remittal. Our primary case aligns with the proper understanding of the Arbitration Act and the fundamental principles and objectives that support it. By contrast, the Czech Republic's primary case is inconsistent with them. Mr. Richards will deal with remittal, and he will also go through the terms of the order insofar as necessary. There are four main points that I will be making as part of my submissions. The first one is that, as a matter of plain analysis, the claim by Mr. Stava cannot be affected by the success of the jurisdictional challenge against Diag Human. The second point is that when one looks beyond the thin veneer of argument about relief or consequences, what one sees is a challenge against Mr. Stava. That's the Czech request for relief in this case. In effect, the Czech Republic is mounting an impermissible challenge against Mr. Stava, which could be viewed as a 67 challenge or as a 68 challenge. But whichever it is no longer open to them. The third point is that the authorities on severability cited by the Czech Republic are not on point and do not assist its case. And finally, the fourth point is that the Czech Republic is completely wrong to suggest that the award in favor of Mr. Stava becomes incoherent without Diag Human. It is a point that they've repeated throughout the written submissions and that my learned friend has traversed again this morning. But our case is very clear. There is no such incoherence. And I will be taking the court through some passages, indeed the passages that they would like to see expunged to show that they should be left entirely untouched. They're completely coherent. I said I was going to focus on our primary case, but a lot of what I'm going to be saying about the fundamental principles and about the coherence of the award also goes to the question of the appropriateness of remittal. Because, of course, if what the Czech Republic is doing is to try to mount a late impermissible challenge, there is no reason why that attempt should be entertained by sending some question back to the tribunal. We're already in the territory where the question that is being contemplated for the tribunal is an impact question. It's the impact on the party that succeeded in defending all the challenges. There may be circumstances where remitting that sort of question would be appropriate, but we would submit the bar is very high, and the Czech Republic has failed to demonstrate that there is an incoherence in this award once Diag Human falls away that is so macroscopic that we need to bother the tribunal, let alone that we now would need to go through the process of constituting a new tribunal. So I will spend a bit of time on these 4 points, which go, I think, to both our primary case and the appropriateness of remittal. In short, our answer to the 3 questions that my Lord Justice Males posed at the beginning is as follows. On damages, we say the award of damages in favour of Mr. Stava should be left untouched. There is no outstanding issue, either as regards liability or damages, for the tribunal or a new tribunal to consider. On costs, our position is that in this kind of litigation, given the sums that we're speaking about, and given the level of interest as well, it would be disproportionate to remit the issue of cost to what would now be a new tribunal. If there is any discretion that is required in making adjustments, and I will explain why no such discretion would be in our favor anyway, it is a discretion that the court is well placed to exercise and can do so much more efficiently at this point than a new tribunal. On the undertaking, similarly, our position is that there is no outstanding issue for the tribunal to consider, insofar as there remains a concern about double recovery. That concern would have to be looked at in the context of the fairness that is owed to the investors, claimants, in this case, and the delay that has taken place in enforcing anything against the Czech Republic. But fundamentally, again, given where we are with the tribunal out of the picture, that issue of double recovery is best addressed by this court in ways that have already been mentioned in the morning, and I will return to that. So that's broadly our position. Now, starting with my first point, the claim by Mr. Stava cannot be affected by the success of the jurisdictional challenge against Diag Human. This is not a complex landscape. There are two claimants. The award in favor of Diag Human is set aside because the jurisdictional challenge on its investor status succeeded. The award in favor of Mr. Stava stands because all of the challenges that were brought against it, and I will be going through them in a moment, all of them failed. And those challenges included challenges concerning Mr. Stava's entitlement to claim, Mr. Stava's position at the time of the request, the connection between Mr. Stava and the investments, the nexus between the investments and the award of damages. All of these issues were raised and they failed as regards Mr. Stava. Now, of course, the Czech Republic's approach, if successful, would have very wide-ranging and systemic implications. And by contrast, our approach is very much the orthodox one, and it is entirely in line with settled principle and the philosophy of the Act. If I could just take the court briefly to a couple of passages of your judgment, which show how the way you approach it in the judgment is perfectly aligned with this plain analysis. At paragraph 143, in introducing, describing the third appeal, you describe the issue, and then at the end you say, accordingly, this appeal concerns the claim by Diag. It does not say, because it wasn't put to the court, that indirectly this appeal concerned in any way Joseph Stava or his entitlement to claim. It was an appeal that concerned the claim by Diag, not the claim by Stava in a direct or indirect way. At paragraph 195, the court says this appeal must be allowed and the award in favor of Diag SE must be set aside. I pause here for a moment because there has been some argument from the Czech Republic about the appropriateness of the language that we inserted in our draft order, which is similar to the language in your judgment, the award in favor of Diag Human. We've spoken of the award in favor of Diag Human, the award in favor of Mr. Stava. The Czech Republic wants to use different words on the basis that such terminology might suggest that there are two awards. We simply use the language in your judgment, which seems to us to be entirely correct and very clear. There is a single award, there are two claimants, and Mr. Stava's own rights and the Czech Republic's obligations to him are recognized in and arise under that award. And while we are still on the sort of at the level of the plain analysis and really basic principles, Section 67(3) gives the court a discretionary power to order certain remedies, including setting aside of the award. It is probably better to read the word award in Section 67(3) in a case involving multiple claimants as the award in favor of the claimant who was successful in the particular challenge. So in other words, that power to order remedies following a challenge and to do certain things to an award is a power that arises from a successful challenge and must be confined to the award in favor of the claimant that failed in that challenge, rather than anything more general. Now, of course,
you mean succeeded?
Sorry? Well, they've succeeded against the...
You mean the power to do things to the award is in respect of the claim which succeeded?
Yes, yes. And the Czech Republic's answer to this case is the domino effect, or knock-on theory, as they call it. They say that their attack a successful attack on the award in favour of Diag Human knocked out certain key elements of the award in favour of Mr. Stava. And that's where I will take your lordship later through the award to show that this is not the case. But just as a warm-up for this analysis, there is one point that has come up in the morning that is rather important. And it concerns the relationship between the question behind the Diag June 2011 objection, where the Czech Republic succeeded, and the position of Mr. Stava. On our case, there are two analytically distinct questions. The question concerning Diag Human is this: was Diag Swiss for the purposes of the treaty when the request for arbitration was filed in December 2017? And that's how Mr. Justice Foxton summarized the question in paragraph 165 of his judgment. This is the August judgment. The request for arbitration is the time when the arbitration agreement between the investor and the state is perfected. If the investor does not meet the qualifications that the treaty requires, there cannot be an arbitration agreement. So at that point in time, as a result of the events in 2011, this court found that Diag Human was not Swiss and did not qualify for treaty protection. It does not follow from this answer, as a matter of law, as a matter of logic, as a matter of fact, then Mr. Stava can no longer demonstrate an entitlement to claim in respect of breaches of the treaty and recover damages for such breaches. On any view, the breaches that predate the disposal are entirely unaffected, and we will see why that's already a complete answer to all the mischief that the Czech Republic is trying to create. But even after 2011, even after the disposal, there is still an analytical distinction between the position of Mr. Stava, any entitlement to claim for damages that he might have had, and Diag Human ceasing to be controlled by Mr. Stava in the sense of Article 11C of the treaty. There are two different questions. And that difference was fully appreciated by the judge. And if we can go to the August judgment, and passages to which you have been taken before, it's actually CB 23. And it's from pages 82. It's CB 23, page 82, yes. It's paragraph 257. Yes. This is the part of the judgment where the judge deals with the issue estoppel application. And in paragraph 257, 258, 259, he considers the relationship between Stava June 2011 and Diag June 2011. And at 257, he underlines those words that are taken from a submission from the arbitral claimants, from us, the words that say they go to wholly separate question of whether D2 held qualifying investments. And then he says the underlying words are correct. That is consistent with Professor Douglas' treatment. That's we had gone through Professor Douglas' work on this issue. He says it is consistent with my analysis that the Stava June 2011 objection concerns the link between the investor and the asset, which is the subject of the claim, and the Diag June 2011 objection concerns the issue of whether Diag is Swiss nationality within Article 11C. He then says the possibility that those different issues might involve different legal tests, and the arbitral claimant's own submissions, which I accepted, that the Stava June objection raised an issue of standing and not jurisdiction, whereas the Diag objection raises an issue of standing. And then he said, the fact that determining the Stava June 2011 objection may involve traversing the same factual inquiry, and it is not necessary to decide whether it would, is not enough. That would be a matter of evidentiary fact. So what had happened at this point in the case is that we had put in an issue estoppel application because we had failed to persuade the judge of our main case, which was that the Stava June 2011 objection was not put. So having unsuccessfully argued that the Stava June 2011 objection was not put to the tribunal, we ran a case that the Stava June 2011 objection having been put and determined by the tribunal, it had an issue estoppel effect on Diag Human. So that was the issue estoppel argument that we were having. And the judge's conclusion, he rejected our issue estoppel application. He analyzes the relationship between those two issues in the way in which he does. And in effect, it is to say there might be a factual connection between those two questions, but there are analytically distinct legal questions, different legal tests might apply, different evidence, as the court pointed out before, different evidence may be taken into account in answering those questions. And so even though there may be some factual overlap, we are looking at distinct questions. And the possibility of factual overlap is the reason why the judge required an undertaking. So he said, if the Stava June 2011 objection, contrary to his finding, was held to be jurisdictional and returned to him, he wanted to be sure that any factual questions that overlapped with the Diag issue were not going to be relitigated, because there was not going to be an issue estoppel on those factual questions. And that's why the undertaking was seen as a fair way of dealing with where we were in the proceedings. But the fundamental point is that there is a clear distinction between those two questions. There is no basis for suggesting that the answer to the Diag June 2011 question must necessarily involve an answer to the Stava questions about entitlement. And that's even before we look at what point they took and failed to pursue. But simply as a matter of analysis of these questions, that's not how they should relate to each other. I should say that in the issue estoppel application, the Czech Republic took precisely this position. If we go briefly to their skeleton, which is here in bundle tab 52, page 9. At paragraph 25. We see.
So sorry, could you give me that?
Paragraph
Here in
50.
bundle tab.
It's here in bundle tab 52. It was added last night, so maybe is it not there?
No, it wasn't.
We've got hard copies.
It's up on the screen.
And it's up on the screen.
Oh, sorry, we don't.
It's just that the paragraph 25, the finding of control is the Czech Republic skeleton, if there was one, by the tribunal as between the Czech Republic and Mr. Stava, even if it had been the same legal issue as that which arises between C and D1 under Article 11C, which it was not, is not capable of giving rise to an issue estoppel. Now, in the latest iteration of this argument between the parties, the Czech Republic now seems to take the view that those paragraphs in the award that go to objection 5, paragraphs 398 to 412, may actually just relate to Diag Human. And so they can be expunged on the basis that they're just about Diag Human. But the key thing, and the judge notes that in his judgment in a previous paragraph, is that there has been quite a bit of position shifting on this issue. But basically, there are two ways of looking at those paragraphs, 398 to 412. One way, which is Mr. Justice Foxton's way, is that they contain a finding that relates to a Stava June 2011 type of objection. But it is also part of the judge's analysis that the question about Stava June 2011 is entirely separate from the Diag June 2011, even if the findings may somehow overlap.
I'm not sure that Mr. Bastian says that those paragraphs are only about Diag Human. Perhaps he said that if you've got a reference, but my understanding was that he says that those paragraphs, our decision about Diag Human paints what is said in the award about Mr. Stava, including what is said in those paragraphs.
Yes, so in their submission, this is the June submission, at paragraph 25 or 26 rather, they seem to suggest that those paragraphs may have been exclusively about Diag Human. Yes, so but the point is that option one is that these paragraphs are just about Diag Human, and they say nothing about Mr. Stava. Option two is that these paragraphs may contain a finding that it would be relevant to a non-jurisdictional issue about Mr. Stava. Whichever of the two options it is, if those paragraphs are in any way to be touched, then the way to do it is to make clear that they are being touched as regards Diag Human, which I believe is a formulation that Lord Justice Popplewell at some point in the morning was suggesting. And the reason for that is because there has been this uncertainty about the correct interpretation of those paragraphs. But at the highest end of that uncertainty is the position that those paragraphs may contain something which is relevant to a non-jurisdictional question about Mr. Stava, but that something is distinct as a matter of legal tests, as a matter of potential factual and evidential inquiry from the Diag Human Swiss question. So that is the key point, I think, about those paragraphs. But it was really a way of saying, if there is anything that needs doing to those paragraphs, it would have to be done with that important caveat, because there has been quite a lot of procedural history, including that issue estoppel application, about their interpretation. But on no view is it the case that those paragraphs knock out a Stava entitlement if they are taken as regards Diag Human investor status point. And that's because of what the judge as well said about the distinction between those two questions. My lords, I had some notes about the Caltex case, but my learned friend hasn't taken the court there, so I don't think I need to trouble the court with that. But I think on the first point, as a matter of plain analysis, there cannot be an impact of a jurisdictional decision on Diag Human on the award in favor of Mr. Stava. The sensitive area, which is why I went straight to this point, which is these paragraphs 398 to 412, is one that is capable of a perfectly coherent answer. Either those paragraphs are just about Diag, or insofar as the judge said, they contain some finding about Diag. It is also the case, as the judge said, that those two questions are analytically distinct. So that's the first point. The second point, which I will develop in three stages, is that the argument about relief or consequences that we've heard from the Czech Republic is really a challenge against Mr. Stava. Now, to make this submission good, I will have to first remind the court of some of the procedural history and the challenges that were being advanced. And then the second stage will be to show that the attack on Mr. Stava today is duplicative of these prior challenges. or if it is not in part duplicative, it should have been brought before. And finally, I will say that this approach creates a problem, serious mischief in terms of the functioning of the Act. Now, on the procedural history, I think it may be helpful to have the March judgment of Mr. Justice Foxton, which is at CB 12, and the amended particulars of claim in front of you. And the amended particulars of claim are at CB 28. Now, as the court will recall, the Czech Republic advanced many jurisdictional challenges, and they are described in the March judgment of Mr. Justice Foxton in paragraph 63. That's at page 19, opus page 19. And just to refresh our memory, there were two separate challenges, as we know, to the investor status of Mr. Stava and Diag Human. They were completely different. One was under Article 11C, it succeeded before you. The other one was under Article 11A, and it concerned Mr. Stava's Swiss nationality. That challenge failed, no permission was given. We then had what came before this court as the Stava June 2011 challenge. That was the subject of the second appeal. Now, it is important to remember that the Stava June 2011 challenge is what survived of a bigger challenge brought by the Czech Republic. And that bigger challenge is at paragraph 4 of their amended particulars of claim, which is at page 7 of CD8. Yes. So paragraph 4 is their entire challenge to Mr. Stava's relationship with the investments, including the effect of the Corona Trust and the Noble transaction. What survived of that challenge after Section 73 was applied to it is the Stava June 2011 objection. This court agreed with the judge that that challenge was not jurisdictional. At paragraph 135, you also concluded, as Mr. Justice Foxton had found, that the challenge was limited to Mr. Stava's inability to claim in respect of conduct after June 2011. And at paragraph 136, the court rejected variant 2 of the Stava June 2011 objection. We had quite a bit of argument at the hearing about variant 2. And this court said that the Stava June 2011 objection cannot be widened into an objection to the position of Mr. Stava at the commencement of the arbitration. So we need to think of what came to this court as an objection that went through a filtering process as a result of the application of Section 73. My learned friend took the court to paragraph 114 of the award, and if we can go back to it briefly, that's SB 23, page 126. The first line of that paragraph 114 is, as regards respondents' argument raised in the request for bifurcation but not reiterated thereafter, that claimants lack standing, it is equally dismissed. Now, the important point is that the tribunal says raised in the request for bifurcation and not reiterated thereafter. One of the arguments that we had before the judge in February of 2024 was precisely what is left of this standing objection, of this APOC 4 objection, if you apply Section 73. And quite any wider point about standing was not given permission under Section 73, was precluded under Section 73, because APOC 4 was dismissed. Stava June 2011 is the point that came to you. So a lot of the arguments that we hear about Mr. Staver's entitlement to claim, entitlement to damages, are really points that have at some point in time been live, but they are no longer live. And for present purposes, it is also useful briefly to recall two further challenges. The first one is the no direct investment objection, and this is described at paragraph 2C of the amended particulars of claim, which is at page 2. And it says at the end, assets held by Conoco in which the award held to be investments are not investments by or made by Mr. Staver. This ground of challenge applies in particular to 384 and 388 to 392 of the award. It's CB/28. Yes, so it's 2C. It's the last sentence of 2C. The judge described this as the no indirect investment objection, and he found that it was barred under section 73. And similarly, what the judge described as the no nexus objection was barred. And that is the allegation that the award of the amount of the 2008 award and associated interest award were not with respect to the investments found to exist. So this is just a...
So where were you reading from there?
That's
Is that in the plea?
from the judgment. That's paragraph 63 of the March judgment, core bundle /12, page 19. That is the paragraph where Mr. Justice Foxton captures all of the challenges. So it was quite a busy landscape of objections where a lot of points were taken. And on Mr. Staver, they all failed except for Staver June 2011. And then there was also the section 68(2) challenge that has been mentioned this morning. Now that's quite important in this analysis because, as my learned friend correctly said, it was a contingent challenge. And the fact that they brought at the outset a contingent challenge shows that they could have brought other contingent challenges. And that is really one of the fundamental features of the Act. If you want to challenge an award, you have to set up your challenges at the outset, and that must include contingent challenges. We're not dealing here with countless permutations. We have two claimants. It was entirely foreseeable that one could have fallen away. And if there is any 68 or 67 challenge that is contingent on that scenario, it should have been advanced at the outset, as indeed that particular section 68 challenge was advanced at the outset.
Was there any submission before the tribunal by either side as to what the position would be if a challenge to jurisdiction or standing succeeded in respect of one claimant but not the other?
I think that before the tribunal as well, all sorts of points were taken. I think it is fair to say that if this particular point had had any preeminence, it would have featured in the award of the tribunal or in a section 68 challenge subsequently. But the section
But it might not have done in the award because it didn't arise, because they found that there was jurisdiction in respect of both claimants. So they may not have felt it necessary to deal with it, as that was their conclusion. But I just wondered if there had been any argument about it.
I think it is fair. I would have to remind myself exactly of what was said then, but I think it is fair to say that the distinctness of the two positions was something of which the Czech Republic was very well aware, and it was advancing points against Mr. Staver and other points against Diag Human, and this question of shareholding arises as one of the key elements of that supposed of that distinction. On the section 68(2) challenge, section 68(2)(d) challenge that was taken, the court was taken to the judgments, to the paragraph in the judgment where the judge explains how he approached it in March and then in August. But it is also important to see the order, which is a core bundle 22, page 6. So that's paragraph 12, I think.
Sorry, which bundle are we looking at?
We're looking at core bundle 22, tab 22.
Thank you.
And the order said, in the event of a successful appeal by the claimant, paragraph 12.
12.
Yeah. In the event of a successful appeal by the claimant, which has the effect that the claimant is able successfully to challenge any award in the second defendant's favour in respect of the 2014 review breach under the section 67 of the Act, the claimant may apply to reopen. So the contingency, as described in the order, is exactly as it was described in that last sentence of paragraph 264 of the judgment. The court has already been taken to that, but it was simply to make good the point that this was the contingency for this particular challenge. And that contingency has fallen away because, as we read the order, it is quite plain in our submission, the Czech Republic could have applied to reopen only if they had been successful in their appeal to the award in favour of Mr. Stava. Because that's how they put their Section 68 challenge. And there was no appeal on paragraph 12 of the order, no attempt to widen at that point or before the scope of the Section 68 challenges. So that's the landscape of challenges that were advanced at various stages and that are relevant to the arguments that are being presented to you, to the court today. So the second stage in the analysis, having gone through this procedural history, is that it shows in our submission that what the Czech Republic is trying to achieve is something that they could not achieve through any of the main routes available to it. Under 67 or under 68. Having failed to achieve that result through a main route, they're trying to achieve it through a side route. And that, under the Act, does not work. Their attempt to argue today that as a result of the jurisdictional challenge to Diag Human being successful, Mr. Stava cannot demonstrate an entitlement to claim or an entitlement to damages is in effect an attempt to repackage some of these objections in a number of different ways. It could be an attempt to rerun 804, which I took you to briefly. It could be seen as an attempt to basically have another try at the no indirect investment objection or the no nexus objection, or it could be tantamount, which is probably what it is closest to a Section 68 challenge, but on a wider basis than the one which they took, including as regards the one contingent challenge that they made. Now, the next question is, what is wrong with this approach? What is the mischief here? And this is where I think it is important to go back briefly to basic principles with which, of course, the court will be very familiar, starting with party autonomy and minimum intervention. The court's findings on the various challenges brought against Mr. Stava confirm that there is a perfectly valid arbitration agreement between Mr. Stava and the Czech Republic. His rights under the arbitration agreement are intact, and he has a right under that agreement and under international law to have his claim determined by an international arbitral tribunal rather than the court. The Czech Republic is inviting the court to displace that arbitral process as regards Mr. Stava by stepping straight into the merits and damages sections of the award, with the consequence that it would be the court and not the arbitral tribunal that would get to decide if Mr. Stava gets £600 million or nothing. And this is really the antithesis of the contractual bargain in the arbitration agreement. And I take those words from the Uvi judgment to Lord Justice Popplewell. Uvi and, probably mispronounce it, Uvi and Interactive Inc. From a few months ago. But it's really about party autonomy. The party had an agreement. The dispute had to be resolved in a certain way. The agreement of Mr. Stava is intact. And that key question of how the dispute is to be resolved is one that the tribunal has already answered. And that answer should be maintained. As far as minimum intervention is concerned, I think I've already indicated my submission here. For the court to make such a forceful intervention in an award where all challenges have failed, the court would have to identify a proper route under the Act that allows the court to intervene in this manner and with this effect vis-à-vis Mr. Stava. No such route is available, but side routes are not permissible, because this really goes to the division of roles between the court and the tribunal that is central to the architecture of the Act, and the principle of minimum intervention in Article 1C of the Act. I mentioned the objective of supporting rather than displacing the arbitral process. That does not feature quite on the face of the legislation, but it's the language that appears in the DAC report a number of times. The reference is, we don't need to go there, but it's paragraphs 21, 22 of that report, and it's Other Authorities Bundle / 2.1, page 5. The approach that the Czech Republic has proposed also represents a direct challenge to the principle of finality. Finality in a case like this has 3 dimensions: a contractual, a domestic law, and an international law dimension. The principle of finality is enshrined in the ancestral rules at Article 34.2, and the parties agreed to arbitrate under those rules. And in Article 34.2, in addition to the award being final and binding, the parties also agreed that there is an obligation to carry out the award without delay. The ancestral rules were incorporated via the terms of appointment, which are a supplementary bundle, tab 9. Finality is a principle in the Act at section 1.1, principle of no delay, but also at section 58, where it is said that the award is final and binding, subject only to the right of review or appeal, and here we only have review, but there is no further review as against Mr. Stava. And finally, Article 9.2c of the Bilateral Investment Treaty provides that the decision of the tribunal are final and binding. Article 9 is the provision in the treaty that contains essentially the compromissory clause. You have the treaty at supplementary bundle / 22. Finality supports our position, our primary position. There is an award in favour of Mr. Stava. The challenges have failed. The award in favour of Mr. Stava must be final and binding and must be carried out without delay.
But doesn't the submission on finality to some extent beg the question, because finality is subject to the court's powers of review under section 67 and 68, and the question is, what is the consequence of the decision that we've made under section 67? So if it follows, as Mr. Baston says it does, then we're not, there's no question of any infringement of the finality principle. And if it doesn't follow, then you don't need to worry about invoking the finality principle. So doesn't the real decisive question come back to whether what I might call merits findings are tainted
Yes.
by the decision we've made on jurisdiction? And if that is the question, what is the test for deciding whether there is such a taint or not.
Yes, and I'll come to that point shortly, of whether those findings are in any way tainted, because there are clear cases that they're not in any way tainted. Finality is still relevant to identifying what that test should be, because we are in a world where one track of challenges has led to success in respect of Diag Human, but the other track has exhausted. And so we are in a world where the question of the award in favor of Mr. Stava being final and binding is the right question to ask. And in considering, in such a world, how to exercise the discretion to remit an impact question that concerns the claimant who has won, one has to bear that principle in mind. I'm not saying that that principle will give the court a clear-cut answer, but it may help the court identify how high the bar should be for a remittal or remission of that sort of question. That's how I would put the point on the relevance of finality.
Yes. Well, I suppose you can, just developing that, you can refine the question I put to you by reframing the question as whether merits findings relating to one claimant are tainted by a decision on jurisdiction relating to a different claimant.
Yes. Well, that was my first point, that as a matter of plain analysis, the jurisdictional challenge on Diag Human can have no bearing on the position of Mr. Stava. That's the plain analysis. If we then get into the weeds of their argument, which is this impact question.
I think my old point was, if you're right about that, then finality doesn't come into it. If you're wrong about that, then one can see that finality might be an argument in favour of our dealing with it rather than having it go back to a new tribunal. But then that cuts across your party autonomy point. But those are all questions which are at a secondary stage, which assume you failed at stage one, and there is something that needs to be done to adjust the merits findings vis-a-vis Mr. Starr.
I see that. I think that the sort of pure position is that there is no need to adjust those merits findings. But if we're in a different world and there is a need for adjustment, then we are in a world of different principles, which is how best to deal with the question of that adjustment and how it should happen. And there I think it's a more uncertain world, but it is still a world where these fundamental principles are to be borne, to be kept in mind. And the point that I would make on the alternative world is that the bar for deciding to make adjustments on the merits must be extremely high. And that's certainly not our main case. Our main case is that we simply don't need to get there. We don't need to ask ourselves, is the award incoherent? Because at the end of the road, which is where they are with Mr. Stava, if they have an award that is in some ways incoherent, they are stuck with it. That's where the clear analysis of the functioning of the Act should lead them to. But if they're right on the knock-on domino effect theory, then the analysis has to be adjusted to that position. But I wouldn't want to say that our pure position, which is there's no way for arguing of looking at the coherence, reassessing the coherence of the award in the kind of scenario where we are. That's our main position, and we very much stick with that. The reason why I'm sort of moving between that main position and the other is because we're so completely convinced about the coherence of the award that in any way we don't think the question of what to do in this extreme scenario is one that needs to be resolved in that case. But why don't I move to that point now, which was going to be my fourth point, but it is of course rather key.
You had a third point, which was cases on severability.
It was the
not on
authorities
point.
on
Are you
severability. I think
passing over that?
I think I can deal with that quite shortly. So the a number of authorities have been referred to, but I think the Czech Republic accepts that what it is advancing is really, I think they describe it somewhere as a novel point. I think on the authorities we can say this. First, the test which the Czech Republic seeks to apply here arises in a context where, as we've seen, the court is considering making further relief in relation to a party against whom a section so the Section 67 challenge has succeeded. So those authorities assume, because that's the premise of those authorities, that they are able to go through the award and identify which passages are impacted by decision on jurisdiction. Those authorities are all essentially dealing with that scenario. But our point is that the court cannot do that or import those principles into this different scenario where we are dealing with the impact on a party that has successfully defended the challenges. This applies to the William Hare case, to which you were taken in the morning. It was a very completely different case. The court was considering the further implications of a decision on an award where the court had succeeded, the claimant had succeeded in their challenge of the award against that party. On the Singapore...
Is that on the basis that if you had, for example, two separate awards in materially identical terms, and one claimant had his award set aside, that wouldn't affect the second award?
The other example we gave, I think, somewhere in our written submissions, is that of a single award with two claimants. One brings a challenge that is not barred under Section 73, and the other one is barred under Section 73. And the claimant that did not have the burden of the bar succeeds. The other claimant does not need to argue because they've got Section 73. And the arbitration claimant, when I say claimant in that sentence, to be clear.
Despite the fact then that the court's decision means that various paragraphs of the award can be said to be, in quotes, wrong.
But the other party is unaffected.
Doesn't affect somebody with a Section 73
it could not be challenged
benefit.
Because Section 73 barred the challenge against that party. And so that's exactly the scenario. What I think, to go back to the previous discussion, finality and all those points matter, because that party is entitled to the final and binding award. They have won. There is no room for further challenges. And there is no reason why they should suffer the impact of a successful challenge brought against another party. That is the plain analysis that we say applies also in this case, where Section 73 did bar a large number of objections that are essentially being repackaged now as argument about consequences. So we're not that far from that hypothetical scenario that we set out, or to the scenario that my lord mentioned about two distinct events. The Singapore case, I think the two points of distinction have already been made. The first one, we can take it, go to it briefly. It's CL30. And the paragraph where, paragraph 73, page 42, the fruit falls the tree. The fruit falls with the tree paragraph is where the court explains that here you had a later order that is ancillary to and depends upon the validity and premises of a prior order. So again, it's quite an extreme scenario. And the other element which Lord Mans underscores later on at paragraph 81, I believe, that's page 46, is that any costs award is normally integral to the outcome of the arbitration. So we're looking at costs awards, which are a distinct determination, and we're looking at this very close relationship between the later order and the prior one. So quite easy to distinguish from the current case. On GD My Dear, it's CL27. So again, a case that is quite distinguishable. First of all, because it is all about a claimant. It is all about the same party. The party that has lost on a point is now open to the possibility that certain revisions are made to their award. But it's also important to see how closely linked here really those determinations were. At page 6, paragraph 10, we see clause 4.2 of the MBA provided that any and all payments shall be made in full within 90 days of the date of each marine bill of lading date. And if we then go, so clause 4.2 was the determination that the tribunal should not have made according to the court. And the court explains why at paragraphs 42 and following, that's page 17, and it says, it is not disputable that the notice of arbitration did not allege any breach of clause 4.2, no reference to any breach of clause 4.2 in the agreed list of issues. And at paragraph 44, tribunal's interpretation of that clause was clearly inconsistent with the position taken by the parties, etc. And then what the court has to decide is what to make of a number of passages that are in different ways related to that clause 4.2 very closely. If we go to the list of those paragraphs, they're at page 30, they're at page 12, paragraph 33. So we see that first paragraph from the award that is being challenged as essentially being inextricably linked to clause 4.2 is paragraph 2.5, then paragraph 2.29 as a result of the breach of clause 4.2 of the NBA, etc. So it was a very different situation. It was one where there was this one claimant, and there is a clear error in dealing with that clause 4.2, and then there are a number of other ancillary determinations around that clause 4.2, in most cases mentioning clause 4.2. The tribunal had to decide what to do with them. So none of the findings are obviously outside the jurisdiction. Now, both of these cases, which I think are the two main cases on which my learned friend has relied, are not on point. I don't think I need to say much about the Privy Council case. Here you had a court referring to arbitrators' issues in a partnership dissolution suit. And I think the key passage, perhaps we can go to it briefly because it just puts in my idea to rest, this paragraph. It's tab 25.2. And it's at page 9. At the bottom of page 9, in their lordship's judgment, such an award is in no true sense one made in obedience to the order. That's the order of the court. It will not be easy to segregate the findings in reference to matters in question in the suit from those not so in question. It is, in their lordship's thing, impossible to uphold an award in relation to a suit, the conclusions of which were plainly colored by the view taken by the arbitrators of other questions. Now, this was a reference by a court under a very old system of arbitration that really can't be taken as good law for the current system of arbitration. And the relationship with the court reference and the circumstances of that case are really completely different. But the key point on the authorities is that ultimately the Czech Republic cannot point to a single authority from a court that has decided under the Act or under a test similar to the one that we apply under our Arbitration Act that identifies this test as severability. Yes, there was severability in awards under the old arbitration regime. But under the old arbitration regime, and that regime is even before the 1946, the 1950 Act, obviously. I think under that regime, it was essentially a system of very high interference by the courts with what arbitrators did. This is how it happened all the way until 1996, in fact. So it isn't really a case that identifies a principle insofar as it does that can be meaningful in the current context. Now, moving on to the coherence point, and the Czech Republic has made quite a lot of this. The argument that the war.
So is that last point you say is all very old cases, and the Singapore ones aren't?
Well,
is that the test in the 1996 Act is different because it's a policy of minimal interference, or what is it?
Yes. So, well, there are a number of differences from the 1996 Act. One of the key ones is minimum intervention. And the other one, we can go perhaps to that passage of the Departmental Advisory Committee, which is at OA. Find it in a second, but it's the objective of supporting rather than displacing the arbitral process. So we have those two principles that are mutually supportive, that are at the center of the Arbitration Act. Courts will interfere less with arbitration. They will do so when there is a route that is provided for under the Act, and they will try to do so in a manner that supports the arbitral process. It's other authorities /2.1/page 5, and it's paragraphs 21 and 22 of the famous report. There is no dispute, I believe, about the proposition that the Arbitration Act 1996 introduced quite a sea change in the way in which arbitration was to be governed. Now, perfect fairness, I don't know exactly what the principles that would have governed arbitration in India in the 1920s would have been in that case that ended up before the Privy Council. But it is no coincidence that there is no authority from the present day and under the Act which reiterates those principles. The Singapore cases are different for the reasons that I noted in relation to those two authorities. But as far as this jurisdiction is concerned, the Privy Council judgment was on entirely different premises. It's almost the work of legal history to try to understand what those premises would have been. But we've had at least 3 arbitration acts since then, and 4 with a new one. So it is almost ancient history. Now the fourth point is on the so-called incoherence challenge. I will, I think, take this point in 4 steps. The first one is to simply say that we are in the territory of an international investment treaty dispute, where different principles apply. And one principle that I'm sure the court is aware of applies is that there is no reflective loss principle in this context. So we can't think of a claim brought by a shareholder in the same way as we would think of that claim brought under domestic law. The second and the third and the fourth step in my submissions will be...
You mean there's no bar on what we would call reflective loss?
Yes, no bar to reflective loss, yes, exactly. And the second, third and fourth steps are on the merits sections of the award and the damages section, and then the undertaking. And I will then perhaps at the end look at a couple of other points that have come up in the morning. It is really quite law, as a matter of international investment law, that there is no bar to reflective loss. We have added a couple of authorities in the bundles. One is a bilateral investment dispute decided by a tribunal chaired by Lord Neuberger. You have it at CL29. I think the paragraphs that capture these points are 77 and 78. 77, the contention that Zhongshan did not hold an investment seems to us to be untenable. The more difficult issue is whether the investment should be treated as its ownership of Zhongfu or Zhongfu's indirect 60% ownership. And then orthodox legal analysis might suggest there should be the former approach. On the other hand, commercial reality can be said to favour the latter approach, in that, in economic terms, Zhongshan indirectly owned Zhongfu's interest. It is not necessary to decide the point because, whichever approach is right, the far-reaching definition of investment is wide enough to cover either the shareholding or Zhongfu's interest. And it says in the next paragraph, it is right to add that even for the purpose of assessing compensation, it would not, in our opinion, matter which was the right approach. We have also included an authority from a textbook, which is at Other Authorities, tab 3, page 17.
Sorry, what?
It's the
before we get there, was the decision in Nigeria case that whether you called it 100% shareholding in Zhongfu or Zhongfu's indirect 60% ownership in the interests, the shareholder recovered 60% of the losses suffered? Was it recovered 100%? I quite see it wouldn't matter at all which you treat it as, whether you look at it as Zhongfu's interests or the investor's shareholding. If the indirect shareholding is only 60%.
I think the challenge, I'll have to come back on this one, but I think on how it was decided, but I think the challenge there was whether the indirect shareholder could have any standing to claim and to bring damages because of this connection with the investment being.
So you just rely on it to say
exactly.
It doesn't matter in this case, but it contemplated that shareholding could be.
Exactly. It's just that principle. Yes. The other authorities to which I think I can probably just briefly give the reference.
You were just going to take us to the textbook, I think.
Yes, Ortino and Myslinski, which is an Other Authorities tab 3, and it's internal page 17. OA tab 3. It's a bundle called OA.
This was the supplementary bundle of authorities, which
yes, I think so. Is it volume 2? Volume 2.
It's in volume 2. It's volume 3. Sorry, volume 3. It's called.
Apologies. And again, this is simply for the proposition.
Sorry, which tab are we at?
It's tab 3, page 17. Shareholders as investors in their own right. It is accepted in international law that shareholders have a right to seek protection independent from the corporation, and then they go on to explain how exit tribunals, investment tribunals, have departed from the position that the ICJ had set out in the Barcelona Traction case. So it is simply to say that it is entirely tried law in international investment law that a shareholder, like Mr. Stava, can claim for loss suffered as a result of breaches of the treaty affecting his investments. And now here, it is important to recall that the investments on the basis of which the tribunal proceeded and on the basis of which the challenge proceeded were the contracts by Conoco the business relationship with Novo Nordisk, the goodwill and know-how. The shares were also part of the investment, but interestingly, they were quite marginal in all the arguments that was had below about the no investment objection. And in fact, one of the points that we made was that the no investment objection wasn't going anywhere because we had the shares as far as Stava was concerned, and so there was an investment. And the judge decided that one has to look at the substance of the investment. We can go to his judgment in March 24, which is at page, paragraph 45, that's Core Bundle 23, page 13. Apologies, it's the August judgment. It's Core Bundle 23. Yes, I gave you the right reference, but it's the August judgment rather than the March one. The reference is correct. And at paragraph 45, he says, in looking at this question of how many investments was it necessary for us to show we possessed, he said, whatever the position may be at the margins, I'm satisfied that the court should approach this issue by considering the substance of the investment established before the court. If that is the same as the substance of the investment found by the arbitral tribunal, then there can be no scope for setting aside the award or remitting it to the arbitral tribunal. And if we go to the arbitral tribunal's findings on what the substance of the investments here was, paragraph 384 gives us the answer to that question, and that's page 120 of the award. The bundle, the opus reference is SB tab 23, sorry, SB 23 tab 8, rather. It's page 120.
120, do you say?
Yes, 120 of the award. Yes, paragraph 384. The tribunal considers that the record before it contains sufficient evidence attesting to the reality of Conoco's business in Czechoslovakia and to claimant's investments in Conoco. And they then go through the various investments, the Conoco contracts at 387, at 389, the business cooperation agreement with Novo Nordisk. They do mention the shares by Mr. Stava in 3191, which were not an issue, and yet we had to go through the no investment challenge. At 392, they mentioned the know-how and goodwill investment. And at 393, they say the arbitration agreement entitling claimants, both of them, to fair, unbiased and efficient proceedings to protect their investment in the Czech Republic. So the arbitration agreement was also an investment of both claimants. Even though Mr. Stava was not a party to the arbitration agreement, it was the mechanism through which he was seeking to secure the protection of his investments in the Czech Republic. Investments is quite a broad concept. I mean, that is the point, and the approach to be taken is a substantive one. And that is why, fundamentally, Mr. Stava, as an investor, having these investments, which cannot be challenged, would have recovered the losses for the breaches of the treaty that the tribunal found, even if he had been on his own. This was not a claim by Mr. Stava in respect just of his shareholding. It was a claim by Mr. Stava, a qualified investor, in respect of a number of protected investments, which were the subject of unfair and inequitable treatment by the Czech Republic.
And presumably you say that that analysis applies irrespective of when the breaches occurred, so whether the breach that one is concerned with is the 2014 breach, which has the effect of making problems for the enforcement of the 2008 award, because that's the main argument against you, is, well, you can't take that into account because it all happened after 2011. You say, well, it doesn't matter because the investment is still there.
So that's entirely correct. We would say that, but we have an even stronger answer because it is one that neutralizes the Czech Republic's attack, which is to say the breaches under the review interference breach are antecedent the disposal.
I mean, that's the argument. The antecedent breach argument was one you aired before us in the last hearing.
Exactly, because we could see that it was really quite a key argument, and that's the one I'm going to go through now. Those are the paragraphs in the merits award that they're trying to set aside. But those paragraphs are predicated on an analysis of breaches that took place for the vast part before the end of 2011. And so that question that would have arisen at the margins, where would Stava stand in terms of his entitlement to claim post-disposal, is not even one that is relevant. It is not one that can be open. That's always our main position. That question is over. But even if it were, it would go nowhere because of the dates in this case. Now, moving on actually to the breaches section of the award, because the Czech Republic is proposing to rewrite the award very significantly. This is no tinkering, as my learned friend put it. I mean, it is a complete rewriting of the award. Now, interestingly, they accept that there is one part of the dispositif that they can't touch. They accept that the breach would remain in the dispositif. That's part of their draft order. Their draft order would still include the words, the respondent breached Article 14 of the BIT. So they accept that Mr. Stava has sufficient entitlement to be entitled to declaratory relief. They are questioning whether he can get more than declaratory relief. The easy answer to that's all merits and damages, you can't challenge it. But we also have good answers on the merits insofar as relevant. Now, on the paragraphs to which my learned friend has taken the point to. So, paragraph 754 of the award. So they want this to be set aside just because it refers to the 2014 resolution. But the paragraph, of course, also refers to the review proceedings being riddled with due process violations. The review proceedings began in 2008. So even on their case, I'm going through these paragraphs on the assumptions that they make about their touchability, which in our view they're not. But on their assumption that one can look at the coherence of these paragraphs, there would still be no basis whatsoever for touching this paragraph that refers to the review proceedings being riddled with due process violations given when the review proceedings began. They then would like the court to set aside three crucial paragraphs that concern the due process breach. They are paragraphs 796, 829, and 831. 796 of the award says in the paragraphs below, the tribunal will explain why it has reached the conclusion that the review proceedings were riddled with due process violations. Of the level of gravity and affecting principles of such importance that the entire review proceedings and the resolution are violative of the standard. Then
that seems to be duplicating 754.
Yes, essentially, because they're moving to the detailed analysis of how the due process violations happened. The paragraphs that.
But I mean, there are two matters dealt with here, aren't there? There's the entire review proceedings, which are mostly before 2011, but not entirely, and the 24 resolution, which is by definition after 2011. So,
yes.
I mean, if we're getting to this level of detail, I appreciate you say we don't get that far. If you're right about that, then all well and good for you. But if we're looking at essentially merits here and whether findings are tainted, subject to the arguments about two different claimants, isn't that a matter for the tribunal rather than for us?
but the question for the court is whether it would be appropriate to remit anything to the tribunal. And it is in that context that it is important for me to reassure the court that there is no incoherence. Because if the court is reassured, not only about my primary case, that this is not stuff that should be remitted in any event, but also on the alternative case, on their assumptions, that there is no incoherence, then there is nothing to remit to the tribunal. Because we don't remit to tribunals academic questions. It would have to be a question of substance that the court has identified as having been properly identified by the Czech Republic. And we say they simply fail at that stage. There is no incoherence in this analysis. If one looks at the dates, which is what I was going to do, that justifies going back to the tribunal, to a new tribunal, and saying, what is the answer to this question? It is entirely clear that the breaches were pre the end of June 2011. The consequence of the breach, which was a foregone conclusion at that point, was the resolution in 2014. But the corruption of the arbitral process happened before. And we know this because the tribunal very helpfully identified different stages in this section of the award, and they all have a date. So we've seen paragraph 796, which they want to expand. And then they say paragraph 796, in the paragraphs below, we will explain why there have been these violations. So the first step, the review proceedings were in breach of fundamental equality between the parties because all the members of the tribunal were nominated by the Czech Republic. They were nominated in 2008. So that's the first step of the analysis. The first due process violation, 2008. The Czech Republic has nominated its own people in the arbitral review panel. The second step, paragraph 802. The tribunal considers that whatever right respondent may have had under Czech law to request the appointment of an arbitrator, it exercised that right abusively. What is the date for this due process violation? 2008, because that's when they appointed the members of the panel. Third step, if we move to paragraph 807, the tribunal considers that the breach of the principle of equality of the parties by respondent was compounded by respondent's appointment of arbitrators who manifestly lack the independence and impartiality, as well as the moral standing to solve the sensitive and high-stakes dispute opposing it to Diag Human. And again, the date is 2008. And so pausing here, a fair and commercial reading of this award, even if it's just stopped here, would already tell us that Joseph Stava has all he needs. The tribunal has found that the Czech Republic corrupted the arbitral process, appointed its own people to the review panel. These people had no moral standing, and it abused its rights and the principle of equality between the parties in so doing, in 2008. And those are the three key ingredients of this breach. But the other violations are still within the right time frame. The fourth due process violations, paragraph 813, says that record shows that the review proceedings were riddled with conduct that was highly suspicious. And we have a number of dates in the paragraphs that follow, and the court can look at those dates. They're all within the time frame before 2011. Paragraph 814 refers to conduct in 2009. And then we have the 2010 resolution, which is mentioned in paragraph 815. Other meetings in 2010 that corrupted, that were part of the corruption of the arbitral process. So all of this conduct under the fourth step is essentially pre-2011 conduct. And then the fifth step, which is the final step. So before I get to the fifth step, we also have that key meeting at paragraph described at paragraphs 820 to 823, 824. The meeting took place in December 2009, and that document...
I thought we wouldn't conclude this hearing without a reference to that meeting.
I haven't used the word, but the date, I need to remind you, the court of the date. and the resolution being in 2010. So these are the 4 steps in the analysis of the review breach. It's all pre-2011. And we have already the breach that we need by step 3, quite obviously. And then the 5th step was the one that is described from paragraph 8 to 5. The respondent was using a criminal investigation which was occasioned by the issuance of the March 2011 opinion. So the vast majority of the conduct that the tribunal looks at in reaching its conclusion on the 2nd breach for which it awarded damages is within the time frame that they must accept. They cannot dispute. So what is there for the tribunal or a tribunal to reconsider in this analysis? If one does take a closer look at how the current tribunal has decided this question of the breach, there is really no basis for reconsidering, and certainly no basis for touching these paragraphs. The court, the Czech Republic wants to remove the concluding paragraphs of this key section, because if it removes those, then it would deprive Mr. Stava of the interference breach. But they simply cannot do that on a fair commercial reading of this award. And of course, the principle of benevolent reading of the awards is one that applies even in appeals under Section 69, a fortiori, in this context, after such a long protracted litigation. It is important to look at this award in a benevolent way, but we respectfully submit that even in a literal close analysis of the award, the Czech Republic simply can't make this case good. And that's just the review breach, because I haven't even mentioned the other route to damages, which is the Boyer letter. Now, on the Boyer letter, there simply isn't any case in terms of...
Just pause for a moment.
Yes.
How are the review breaches a route to damages which the tribunal held had been suffered in the amount quantified in the 2008 award, which seems to me to presuppose they had all been suffered prior to 2008?
I think the reasoning of the tribunal was that there were 2 different breaches. There were the original breaches from the Boyer letter, and then the parties had agreed an arbitral process for dealing with that dispute arising from the Boyer letter. That arbitral process, notwithstanding some interference, led to a conclusion in 2008 that quantified those damages, and that's the final award. Following from that conclusion, there were the further breaches. The tribunal decided that the 2 breaches could be quantified in the same way by reference to the 2008 award. The Boyer letter breaches could be quantified in that way because that's what that commercial tribunal was seeking to do, although under a domestic cause of action. The review breaches, the tribunal concluded, could be fairly still calculated in that way because the key mischief of those breaches was to deprive the claimants of an opportunity to vindicate their rights and to pursue their rights through the process that the parties had agreed.
Well, I can understand that
Yeah.
vis-a-vis Diag, because the reasoning could be that the 2014 resolution has to be removed because that has deprived Diag of an award in its favour. But if the award was not in favour of Stava, but was simply a quantification of the damage which he had already suffered by reason of the earlier breaches, how does that reasoning apply to his damages?
I think it applies to his damages because they look at Mr. Stava as the investor who had those original investments in the Czech Republic that were damaged in a certain way, and that being privy to the arbitration were quantified in a particular way by the commercial tribunal. And so those damages are a fair way of assessing, in a commercial way of assessing, the damages that this investor suffered as a result of the destruction of his investments in the health sector in the Czech Republic.
And that's all That's all by reference to the breaches in the Beaujard letter and its consequences. What I don't quite understand is how that can logically have been a consequence of any breaches so far as he was concerned.
Well, he's still
in the review process.
He's still concerned about those breaches because he, being the investor who made the original investments, then transformed that investment through an arbitration agreement in a process for resolving the dispute that had emerged with the Czech Republic. And that's why that passage in the award, where the tribunal said the arbitration agreement is an investment of both claimants, is quite important in this regard. The arbitration
that was the bit arbitration agreement, wasn't it?
No, there was the arbitration agreement that led to the 2008 award, was that arbitration agreement.
Just show me that again.
Yes.
Thought.
394. Yes, 393. The arbitration agreement entitling claimants to fair, unbiased and efficient proceedings to protect their investment in the Czech Republic.
Yeah,
Also qualifies as an investment.
That's the bilateral investment treaty.
No, it's the commercial. We can show that. I don't think it is in dispute with the other side, but I'm sure if we if I go
to a reference to Article 1 and 2, at the end of that paragraph.
we go to the claimants. Yes, paragraph 141, page 26. Yeah, so the term arbitration agreement is the agreement concluded. 141.
Mr. Starver was a party to that arbitration agreement, was he? Although he was not a party to the proceedings.
That from the investment law analysis, what matters is that he was the investor who had made those investments, which were now being protected through this route. And even if he wasn't formally the party to that particular agreement, he was still an investor with sufficient standing in respect of that investment. And the arbitration agreement was an investment made by Mr. Starver.
How can it be in the future?
It's
I have to say, then I see what's said about the definition of arbitration agreement in 141, but the terms of 393 are referring to the protections that are afforded by the bilateral investment treaty, aren't they?
But I think what he's saying, what the tribunal is saying at 393 is that the arbitration agreement, defined as we saw before, qualifies as an investment, and particularly as claims and rights to any performance having an economic value, which is the term from the BIT. So that arbitration agreement meets the definition of investment in the BIT. That's the point they're making. And the Foxton August judgment deals with this at page 41. It's CB 23.
Sorry, give me the reference again, please. Sorry.
It's CB 23. 23.
CB 23,
Yeah, page.
Page
41 and 42.
41, 23.
Paragraphs of 140 and 142.
And
Sorry, which paragraph are we looking at?
from 140 onwards. So it starts at paragraph 134. So that's where in the August judgment the judge dealt with the question of whether the arbitration agreement was an investment. And he says at paragraph 134, the tribunal also found that the arbitration agreement constituted part of the arbitral claimant's investment. And then he deals with it. At paragraph 140, he says the issue of whether an arbitration agreement can constitute a distinct investment, if that means that it may satisfy the concept of an investment independently of any underlying investment to which it is linked, is controversial. and then he says, I'm satisfied that an arbitration agreement can be a crucial step in the continuity of investment between the original investment and any final investment in final arbitration award, and in an appropriate case can be regarded as a continuation of that investment. So the arbitration agreement was a protected investment.
But he then goes on to speak about the bespoke arbitration agreement after Kaneko had commenced court proceedings, which is obviously referring to the 1996 arbitration agreement.
Yes, it's the 96 arbitration. So the 96 arbitration agreement is a continuation of the investment that these parties made. These parties, Mr. Stava makes an investment, the Conoco shares, business agreement with Novo Nordisk to goodwill and know-how. There is a dispute, that investment suffers, is destroyed effectively. And then there is an arbitration agreement a few years later to decide, to resolve that dispute. And what the judge is referring to here is the cases that we've been discussing quite a lot before him, that make the point that an arbitration agreement is a protected investment under an investment treaty, particularly where it is the continuation of an underlying investment. So in this case,
is the process of reasoning, if he had an investment, a qualifying investment in his own name,
yes,
because he was a shareholder, and the fact that the company's investment is protected by an arbitration agreement to which the company is a party, but he is not, doesn't stop it being a continuation of the protection of his investment for a shareholder. Is that
where I hesitate is only the shareholder bit. So yes, he was obviously a shareholder, and that was a connection with these investments. But the key test in terms of investment law is a looser one, is not as strict. It's whether the investment was made by that investor. And in this case, that point no longer being challengeable, all of these investments were investments made by Mr. Stava.
In order to address the question, how can the arbitration agreement be an investment of his if he's not party to it? You have to add something, don't you? Which I thought might be that it's an arbitration agreement with a party in which he has
Yes,
a coextensive investment interest.
yes, plus
Great shareholder.
exactly, and the original investments that were made. So that is the nexus between him and the arbitration agreement that ensure that this arbitration agreement can be characterized as an investment made by Mr. Stava. But that's the basis on which everyone proceeded. But to go back to my Lord's question on the damages, once this whole picture is looked at comprehensively, of how the dispute evolved and the relationship between Mr. Stava and Diag Human and the investment, it makes sense for the tribunal to conclude that both routes for damages could probably lead, and anyway, that's their decision on damages and on the merits, could probably lead to that assessment of damages. And there is no incoherence or oddity about that assessment of the review breach applied to Mr. Stava as well, because after all, in the very substantive way in which investment treaty law looks at these relationships, Mr. Stava was an investor. He came in and made these investments. He suffered as a result of interference with those investments. He agreed through Diag a process for solving that disputes, and the investments were still destroyed, but there was a quantification of the damage, and that is the quantification that should apply equally to both. I should say there was some attempt that we made to argue that different ways of quantifying different damages should be embraced by the tribunal, but they were not with us. They decided to go with the 2008 award assessment for both routes of damages. Yes. Now, we spent a lot of time on the review brief, but of course, because I wanted to clarify the point that the review breach is very much on the assumptions that the Czech Republic makes still entirely coherent in the analysis of the tribunal. Now, on the Boyer I'll come to the Boyle letter actually, sorry, in a second. Just before I come to the routes for damages, there are other paragraphs that the Czech Republic would like to set aside. I'm not going to take the court there, but just mention them. 849, 885, and then 914 and 915. These paragraphs concern findings which the tribunal did not consider it had to make for reasons of judicial economy. We had made a number of claims under other provisions of the treaty, like the umbrella clause. The tribunal decided that there was no need to determine these claims. And we can see no basis whatsoever, again, on the assumptions that the Czech Republic is making for looking into the merits. We still see no reason whatsoever for these paragraphs having to be set aside. Even if one accepted that we have to do this sort of coherence review, what they are proposing is actually rather incoherent.
And it might be said that it favours you, because if it went back to the tribunal, it would mean that the tribunal could revisit the fact that it hadn't decided those points.
Because the reasons of judicial economy
Yes.
would have changed.
Yes.
Yes.
I don't suppose you would resist this if the other amendments are being made. If the other amendments are being made, then presumably you would want these amendments to be made.
Well, I think that the point of their amendments is if that is the point of the amendments, which I don't, the point I think of their amendment is the opposite. But if that were the point of the amendment, then perhaps. But anyway, they're not amendments that we think would be. I think they want the claims dismissed in some sense, rather than the judicial economy.
It seems to be on their face. They're saying you can have these variants so that goes back
And rerun
by way of permission along with all the points they want.
Well, if that there is no mischief, then perhaps there isn't any need to go there. But going to the damages, which is where they are seeking essentially to expunge the entire section of the award dealing with damages. If I can just take the court briefly to Mr. Justice Foxton ruling on PTA, where he just very crisply summarised how the award should be read on damages. And we have that at Core Bundle 24, page 3, or Core Bundle tab 24. And he says at paragraph 8, the arbitral tribunal, as I read and have always read that award, identified two routes to the relief they ordered. They identified a route on the basis that there was a breach of the investment treaty in the sending of the Boyle letter, in respect of which they deferred to the 2008 commercial arbitration award as to the quantification of that loss, and a route whereby there had been a breach of the treaty in relation to conduct leading to the 2014 resolution. Which was appropriately compensated, as they put it, by failing to recognise the 2014 resolution in the international legal order. That, we say, is the simple, correct and commercial way of reading the tribunal's reasoning on that award, and it applies perfectly coherently to Mr. Starmer.
In other words, review breaches didn't cause any damages.
Well, they did cause damages at that point. Because of course in 2008 he still had control of still had control of the final award, still had control of Diag even on the analysis of the control question being dispositive of all control issues. The way the judge describes the conduct leading to the 2014 resolution is quite important, because the 2014 resolution, as the tribunal saw it, was the consequence of the illegal acts. Once you have created a tribunal that is made of people of no moral standing, whom you have chosen, they will, in all likelihood, decide what you want them to decide. And if that decision happens in 2014, 2015, or 2030, it doesn't really matter. The tribunal decided that the consequence of the illegal acts, namely the 2014 resolution, was a non-fact, or was deserving of known recognition in international law, because it was the consequence of an illegal act. but the illegal acts that produced it happened before the 2014 resolution. And that's why those first three steps in the analysis of the review breaches are quite key. So our case on Mr. Stava is that this reading of the award of damages applies to him perfectly coherently under both routes of damages that the tribunal had identified.
So is the analysis then that if you ask yourself, well, what is the value of shares in Diag immediately before the transfer into the Corona Trust, you would say to yourself, well, it's got a 2008 award in its favour, but there's a review proceeding going on which is so corrupted that the result is inevitably that it's going to be set aside and worth nothing. Is that the analysis?
So because you have shares, but you have this Damocles sword that's about to fall, that has already fallen really on this investment, and that has made it essentially worthless, or it has destroyed the economic value, and that's why
unless there is some Damascene conversion for the
by
review
the three
arbitrators.
arbitrators, which unfortunately did not happen. So that's, in our view, is a reading of the award that is entirely coherent, that is perfectly sensible. It does not leave any question outstanding for a tribunal, let alone a new tribunal that would have to come to this completely new, trying to make sense of a very long procedural history. It's crystal clear. There were these two routes. The dates are clear. Even if, which we've never accepted, even if the loss of control over Diag had the extreme consequences for Mr. Stava that they contend for, we would still get all we want because of the merits breaches, the dates of the breaches, and because of the two routes for damages. Now, they might try to say, well, what about Mr. Stava's entitlement to claim damages subsequently, etc. At that point, they try to run it, and that's been run as a non-jurisdictional point on the narrow basis on which the Stava June 11 objection came to you. It couldn't be run on a wider basis. And if it had been run, we would have had very good answers to it, precisely for the reason that my Lord Justice Wales mentioned, that the key breaches that destroy the economic value of the investment happen before the disposal. And so in some ways, as in a case of expropriation, the fact that you've lost the right, you've lost the economic title, does not mean that you've lost the right to claim in respect of that destroyed investment of which you've been dispossessed. And again, it's an area where there would be a lot of case law, the effect of disposal, dispossessions on the entitlement to claim, etc. But it is not an argument we need to have. It's an argument that could have been had before. In some ways it was had before, and they lost it. But it is not a question that any tribunal needs to be troubled with at this stage, is how we see it. My lords, my lady, on the
Now, how are we doing? Because you're still going. Mr. Riches wants to say something, and we must have a little time for
I'll
Mr.
do
Bastin.
5 more minutes, because I keep being passed messages in Mr. Richards' handwriting, which I can't decipher, so he will have to say what he wants to say. Oh yes, I think this is accepted, and that the Boyer breach happened in 1992. Just wanted to make sure that we have that date.
And the acquisition of his 100% shareholding through Diag AG was in
2001.
1993, was it? It was after the Boyer breach.
By 2001. Yeah.
I think it was.
Can you, Mr. Richards will give a precise. I think we're getting two different answers, 93 and 2001. We'll get exactly that answer. But on that,
I think we said in our judgment 1993.
then I'm sure it must be right. But I think on the shareholding, that's where that contingent challenge is quite important, because it was a contingent challenge. That contingency has fallen away. But if they're trying to run a wider shareholding challenge, wider than they want them to one that has fallen away, through consequences of relief, that simply cannot be allowed to work. They shouldn't be allowed to do that. But that's really what they're saying. If they want to now run a challenge on shareholders, why didn't they do it sooner? Now, I think very briefly, because Mr. Richards has to get on his feet. On the undertaking, the undertaking, which we now have somewhere in the bundles, the undertaking is signed by Mr. Stava in his individual capacity, and then by Mr. Stava on behalf of Diag Human. That's the undertaking which is still there. It's not being withdrawn. It's still there. There wasn't any suggestion that absent an undertaking, the consequence for the investors in the dispute, in the investment treaty claim, should have been no damages. And realistically, that would have made no sense for the tribunal to say, well, it's either an undertaking or we will award no damages. In any event, we accepted, and we still accept, that double recoverability is an issue that the tribunal wanted to address, and that this court may also want to address. But we don't believe that it is an issue that needs to be remitted to a new tribunal. To begin with, the tribunal would have no jurisdiction over Diag Human. At this point, both Mr. Stav and Diag Human are before this court. And so there is a possibility of engineering some sort of undertaking that would protect against the risk of double recovery that is similar to what the tribunal did and that might involve both parties. However, we would respectfully invite the court in considering the fairness also to Mr. Stava and Diag Human, given how long this case has gone on for. Mr. Stava has no interest whatsoever in double recovery. He would be perfectly content with an undertaking that says that that situation will not arise, and if it arises, he will return whatever is in excess. But in a context where the Czech Republic is seeking to remit certain issues, to constitute a new tribunal, we may be looking at a very long delay on this award. And one has to consider whether it would not be disproportionate in this context to tell Diag Human you can do nothing on the commercial award either. There has to be some mechanism to ensure that there is no double recovery. That mechanism could be Mr. Stava undertaking not to recover under this award beyond anything that Diag Human has managed to recover in the meantime under the 8 award, and to return any such excess. It could be in that form, but it would all come to Mr. Stava.
And Diag giving an undertaking to the same effect in reverse.
Exactly.
An undertaking from each of them, and not to seek to recover under their respective awards to any greater extent than the total of the awards.
But I think that the situation that one needs to be a bit careful about is one where the recovery, given how long has gone by, 2008-22 award, is procrastinated further because of a double lock undertaking. That means neither can do anything. And if there is remittal, that's the sort of situation that I have in mind. If we have a remittal at this stage and we have to constitute a tribunal, this award will not be in the enforcement space for a while. And to tell Diag you can do nothing with your 2008 award while this other award is being resolved is quite a big ask. I'm not saying that it is not an ask that our clients will not be prepared to give. But what I'm just saying is that the key concern, and it is one that both Joseph Saab and Diag Human will accommodate fully, is to ensure there is no double recovery. But we need to find a way, perhaps, of making sure that the procrastination, which has been really quite an obvious gain by the Czech Republic in this litigation, does not penalise them.
Well, they did win.
Well, they won on the Diag Human challenge, yes, but not on the 2008 award and not on Joseph Stava. But
can I just be clear what you're saying? Have I correctly understood that you do have instructions that you would, in principle, be willing
yes,
to give those undertakings we've identified, both on behalf of Mr. Starver and on behalf of Diag. But if there is to be a remission, then what?
Well, then we are concerned about the timing. And,
What is your?
well, the concern is whether at that point it wouldn't be better for Diag Human to start enforcing the other award, given how long this thing is going on for, quite frankly. And that would be done under a clear undertaking that there wouldn't be double recovery. But that award is still there.
I'm not sure that the undertakings that you've suggested would preclude it from doing so. Would it?
No, exactly. That was the point. I'm sorry if I laboured it, but
That's not an additional problem.
that's the point that I was making. But the undertaking before the tribunal probably precluded that.
I think what you're concerned about is that we don't seek to extract an undertaking from Diag that it won't enforce the 2008 award,
Yes,
Which is not what is
Which
being
is-
suggested.
not what we've suggested at all.
that's that. Then I'm sorry for labouring the point, but that was exactly the concern.
I think you need to go away and look at the transcript of this part of the hearing and let us know precisely what undertaking Diag is proposing to give, and or Mr. Starver is proposing to give to meet this concern of double recovery, because what we will want to do is go away and decide
Yes.
what our order is going to be. We will not want to get into a negotiation with you about what undertaking you might or might not be prepared to offer. And you need, therefore, to consider the position really on, I suppose, three possible bases. One is that we don't remit anything. One is that, another is that we remit costs and damages. The third is that we don't remit damages, but we do remit costs, to which different considerations may apply. But if you can formulate, perhaps there's,
Sorry,
I'm sure my lord can think of more than I can.
A fourth maybe, and this may be important, that we might remit just on the double recovery point in the absence of a satisfactory
Yes.
undertaking.
Exactly, which is my concern, of course, because we'd rather give an undertaking that fully satisfies the proper concerns about double recovery,
And have
then
the same
be in a
back.
space of remittal.
Yes.
Not least because this is a question that this court is best placed to deal with efficiently, more than any tribunal.
Yes.
And Diag Human is before this court.
Well, we can understand that, and also that if double recovery is the only point, then it would be to everybody's benefit to avoid having to reconstitute a tribunal just to deal with that. But you'll see on the transcript what's been said,
Yes.
and you will let us know what you're prepared to offer to meet this point.
Yes, we will do that. And two very brief final points, and then Mr. Richards will be on his feet. One, while we are on the undertaking, there is a case that we've added to the authorities. It's a CL tab 32. And it's a judgment by Mr. Justice Foxton, where he was also dealing with a situation where the court had to consider the possibility of an undertaking in a Section 67 challenge. And this was simply to make the point that the court considered in that case too that it could have obtained its own undertaking as part of the relief it was willing to grant. And we simply had that case insofar as there was any issue about that, the suitability under Section 67 of that solution, but there does not seem to be. The second point, very briefly, on costs. In the BIT arbitration, we had 70% of our costs reimbursed. The costs already reflected a discount, but the other side will say they should reflect a further discount because we succeeded on Diag Human. In exercising any discretion, a tribunal would also probably consider the fact that quite a lot of the evidence that was brought before the court on the Diag challenge was not before the tribunal, in particular the Liechtenstein law evidence. So they might exercise some discretion and give another cut on the costs. But in the scheme of things, and given how large this claim is, and given how much the interests are, and given the costs of constituting a tribunal, the idea that we should go through that process to remit to the tribunal this question seems to be disproportionate. And again, this court, in its role of supporting the arbitral process, is best placed to deal with that issue as well. It is not an issue in the exercise of your discretion on remedy that deserves that process of constituting a tribunal and having argument about cost, whilst it can be dealt with more simply before you. That's all I was going to say on costs.
Yes, Mr. Richards.
My lord, my learned friend Lord Verderami has addressed this on our primary case, so it's perfectly fair that he spent a lot of time on it. I will rapidly go through the questions concerning court's power on remittal, whether those powers arise in this case or ought to be exercised in this case. Thirdly, if they are to be exercised, how they should be exercised. And then I will briefly just look at the terms of the order at the end. So turning to the first, in terms of the court's powers, I don't believe it's controversial between the parties that the court does have the power under section 67 to remit. That is recognised in the Law Commission report that led to the 2025 Act. And I can give your lordships and your ladyship the reference, but I don't suggest we go there. In the bundle, it's at OA, which I think is other authorities, tab 5, page 115, and that is where the Law Commission review, paragraphs 9.140 and then also 9.143, set out the fact that it is it recognised that the courts already, in a number of authorities, have exercised powers to remit equivalent to or on the same terms as under section 68 and 69, where those powers appear expressly, and the new wording of the 2025 Act reflects that position. Now, as I say, I don't believe that's controversial. So, even prior to the 25 Act, this court has the power to remit. Now, the question...
that part of the new Act's not in force yet, is that right?
The express provision is not enforced. The point being, under the 96 Act, the authorities indicate, and the authorities are those that are referenced at paragraph 9.143 of the Law Commission review. Those authorities set out a number of situations where the court has indeed remitted in respect of 67, even though there's no express provision for that. And essentially the point is the 2025 Act merely reflects what is already the law, but it does so in a way that means it's not express. That is remittal, so formal remittal under 67. My learned friend in his proposed options also addresses the principle that arises under the case of Hussman, which your lordships and your ladyship will have seen reference to. And just briefly running through that, that is a situation where, by reason of the relief that the court orders at the conclusion of a 67 challenge, a gap essentially appears, which means that the tribunal has not completed its statutory and contractual duty, namely to render a final award on the merits. That gap, therefore, needs to be filled, and on that basis, it is said, as was most clearly expressed in the case of Hussman, I'll take your lordships and your ladyship just to one paragraph to illustrate this. The authorities say that the tribunal's jurisdiction revives to the extent of that gap, so that it can then continue to exercise its statutory function to render award on the merits to fill that gap. And if I could just take the court to that, we see that at CL tab 8.
Well, I'm not sure there's any dispute about this, is there?
Where there is a dispute, my lord, is what situation we are in here. So that's why I want to take your lordships and your ladyship to it, to show there are essentially three options, three scenarios that the court contemplated in that case. And for that reason, I would just suggest we go there, just so we can see that. It's CL8, and it's paragraph 83 of the decision. And if we just, which is at page 20 of the decision.
I mean, if you're taking to this, how long are you going to be, Mr. Riches? Because you've got
Overall.
about 7 minutes left.
Yes, my lord.
Well,
Can I make my
Mr.
submission?
Baston's got to say something. So
There are three points, three scenarios. One is where there is only award only on jurisdiction and it's set aside in terms or declared of no effect. And in that situation, the tribunal is not functus, and there is a need for remission because its jurisdiction simply revised in order for it to complete the task. That's scenario one, and that's the first sentence of paragraph 83. Scenario two is the first part of the last sentence, and that is where a valid final award on the merits will, of course, exhaust the arbitrator's jurisdiction, subject to any remission from the courts. That's our case. In other words, tribunal's jurisdiction is exhausted. And then after the semicolon, the second part of the last sentence, where there is an invalid final award in excess of jurisdiction. And in that situation, again, the tribunal is not functus, its jurisdiction simply arises. So, going then to applying that to this situation, are we in a position where the Popplewell principle applies? In my submission, no. The reason being that there is a final award on the merits in favour of Mr. Stava, and what the Czech Republic is doing, and this is its first alternative on its draft order, it is saying that this court should set aside certain paragraphs of the award, and by doing that, automatically or implicitly or silently, the tribunal's jurisdiction will revive, and it therefore then needs to fill that gap. That is the mechanism that my learned friend seeks to use on his first alternative. And in our situation, that is entirely artificial in the present scenario, because there is already a final award on the merits in favour of Mr. Stava. And what my learned friend has to do to get over that is to have this court intrude into that award, set passages aside, particularly the dispositive parts of the award, in order, artificially we say, to create the gap for the tribunal's jurisdiction then to arise. And it simply is not an application, a proper application of the Hussman principle in our submission. In Hussman, the tribunal had no jurisdiction over the company where an award had been made in favour of that company. In our situation, that is not the case. The tribunal did have jurisdiction in respect to Mr. Stava. That's not disputed. The Czech Republic accepts that. It also found legitimately that there had been a breach of Mr. Stava's obligations. They accept that. So the only question that they said remains is that of whether the damages that were awarded to Mr. Stava should stand. And that is not a situation that is remotely comparable to the one that arose in the Hussman scenario.
okay, well, we got that point. We've
Yes.
got quite extensive submissions in writing. We really need to conclude within a couple of minutes.
So that is that, my lord. Further point, to remit, this is a point that applies more generally, would be inconsistent in our submission with the principles in the Act. It would be inconsistent with the principle of non-intervention for the reasons that my learned friend has set out. It is also inconsistent, in particular now that we have a tribunal that's indicated that it will not act further, and therefore it seems the need to constitute a new tribunal, an inconsistency with section 1A of the Act, and the need for achieving resolution without unnecessary delay or expense. And the proposal that my learned friend makes would lead precisely to that outcome. We would have constitution of a new tribunal, the need to read in consideration of the previous tribunal's considerations, and also of the award and of the facts as they see it, a complete relitigation. And that, in my submission, would be wholly inconsistent with the principles set out in section 1 of the Act. And just picking up on a couple of the points that have arisen during the course of the submissions today, that goes to the larger point about an analysis of the merits. What about the amendment that my Lord Justice Popplewell suggested to paragraph 413? What about costs? What about undertaking? In all of those, on all of those points, given this court's now familiarity with the matter before it, and given also the inevitable delay and expense that would be required to send this matter back to the tribunal, we are not in the situation where it would be appropriate, even though the court has the power under section 67, it would not be appropriate to remit this matter to the tribunal. If your lordships and your ladyship are minded to remit, how is that to be done? Again, it should be constrained by the principles set out in section 1. It seems that the Czech Republic wants the tribunal to consider matters completely afresh. In our submission, that would be wholly inappropriate. And we can see the reference to that. I'll just give the reference for the transcript. In my learned friend's second submissions, paragraph 25, where they indicate that if there is to be a remission, it should be to enable the tribunal to consider matters afresh. And that's paragraph 25, and that's HB tab 16, page 7. That must be wrong. It's also wrong on the authorities. And we put in the bundle on authority a decision of Mr. Justice Langley in the Allegro case, and that is at CL 31. And I can just read the relevant passage to the court, which is that paragraph 76, which is at page 14. The effect of remission of an award following appeal is to allow the tribunal to redetermine the cases that were advanced before it, rather than to present a new case that may have emerged during the appellate process. There's a reference to Russell, and also a reference to decision Van Giesen de Noord shipbuilding, in which Justice Christopher Clark, as he was, said it seems to be most undesirable that appellants should be able to open up the entire subject matter of those part and to run, for instance, points that were never taken before a tribunal. And again, so we say here, if there is to be remittal, it should be in a constrained way. And I will take you in the.
I'm afraid you won't. It's up to your team to decide how to organise your time, and we must allow Mr. Bastin at least a few minutes to respond.
Great, my lord. Might I just make one or two very brief points on their order? You'll have seen our order, so it's simply the final point on their order, my lord, which is a point came up during the course of submissions this afternoon when Mr. Bastin said, we don't intend to, I think he was saying, we don't intend to preclude you from running any of your other claims which the tribunal didn't decide for reasons of judicial economy. But in their draft order, they do have a provision that suggests, that indicates that the tribunal should dismiss all other claims. And that would be inconsistent with my learned friend's submission. If he's saying that, that's fine, we accept that, but then that would need to be deleted. And then, my lord, another point that I ought to pick up on, in their final option, they seek to, in my learned friend's words, scoop up the remittal award in any remission to the present tribunal. There's no jurisdictional basis for that at all. There is a challenge in respect to that remittal award before the curial court. So it's unclear what mechanism would permit that matter to go back to the tribunal now before any first instance judge has looked at it. My lord, I would urge the court to look at our draft orders after this hearing when it's considering this matter. We have two draft orders. One is our primary draft order, which set out essentially what my own friend Lord Verderame was making submissions on, whereby the court can deal with everything, and that would include undertaking costs and any amendment. There is an alternative draft order which sets out a situation where the court contemplates remittal, and we've set out the restrictions.
All right, well, we'll look at those.
I'm very grateful.
Thank you very much.
My lords, my lady, I will be focusing on damages, and if there's time at the end, I'll deal with a couple of small points. My learned friend, Lord Verderame, referred to a statement by Mr. Justice Foxton at the October consequentials hearing. There, the judge expressed a view that what the tribunal was actually doing in the quantum section of the award was also saying that it was awarding damages in the amount of the 2008 award for the 1992 Boyar letter breach. This was the two routes through that my learned friend referred to. What I think is important for the court to appreciate is that that is one interpretation of what is happening in those paragraphs around 1026 to 1033 of the award. But there is an alternative interpretation as well. Indeed, there had been extensive argument in front of the tribunal with expert evidence about the proper quantification of loss caused by the Boyar letter breach in 1992. There had been extensive argument before the tribunal by the defendants, the arbitral claimants, in which they said that various findings in the 2008 award, commercial arbitration award, although not the ultimate damages figure awarded, created issue estoppels in the BIT arbitration. They then sought to rely on those issue estoppels in the damages case that they advanced before the BIT tribunal for the quantification of loss caused to the Czech businesses. The tribunal rejected a case that it was bound by those findings via issue estoppel. If we can have on the screen A3/8/160, the tribunal said at award paragraph 506, moreover, in the particular circumstances of this case, the tribunal also considers that, due to the highly disputed nature of the underlying events, it is duty-bound to examine the record before it and to reach its own conclusions on the facts of this case. It then went on through the award to make various findings that, because of the FET breach arising out of the review proceedings, the 2014 resolution was not entitled to recognition in international law, and the 2008 award was to be recognised. As noted in my earlier submissions, those findings regarding the 2014 and 2008 award are affected by the position on trust and control determined by this court. Now, when one goes back to the damages part of the award and walks through the quantum reasoning, it's easy to pick up this point. If we can have on the screen, please, A3/8/315, we'll see the tribunal dealing with this as a matter of fact at 1026. There it says at 1026 that the partial award in the commercial arbitration and the 2008 award quantified the damage caused to Diag as a result of the Boyar letter. Now, of course, that was quantification in a Czech competition law claim in the commercial arbitration. The tribunal then moves on to note the breaches that it held to exist. The first one it notes is the interference with the commercial arbitration, which it said did not affect the outcome. Then it notes at 1028 at the bottom of the screen, interference in the review process. This is a paragraph which, as the court knows, I say cannot stand given the court's findings as to the trust and control. And that is because it is dependent on Mr. Stava being able to advance claims regarding the 2008 award, even after that had gone into the trust when he alienated his shares in Diag. So this is a key part of the quantum reasoning which on my submission falls away as a result of this court's finding on jurisdiction. Whatever rights Mr. Stava had as a shareholder investor, which is what my learned friends have been emphasising in strong terms to the court, were transferred into the trust. Quite a simple point. Those rights are gone. So this is a key part which is affected in the quantum reasoning of the tribunal. Then on to 1029 on the next page, please. The tribunal says that recognition of the 2008 award as valid in the international order will compensate the arbitration claimants for the remaining damage suffered as a result of the Boyar letter breach, the 1992 breach. Now, again, I note that this paragraph falls for the same reason. But can I just focus on what the tribunal says in 1029? I'll pause just to allow the court to read. There the tribunal is saying that recognition of the 2008 award in the international legal order will compensate the claimants for the remaining damages suffered as a result of the Boyar letter. It is not saying that the amount of the 2008 award is itself a proper quantification of loss due under the treaty for the Boyar letter breach. This is instead a statement that the tribunal has already indicated that the 2008 award is to be recognised. And that conclusion having been reached, the tribunal is saying that that will obviously compensate for any remaining damage done by the Boyar letter breach. Quite a different point. The tribunal is not saying that independently they have gone away and think that the 2008 award quantifies the amount that would be due under the treaty for the Boyar letter breach. One then reads on to paragraph 1030, and that's where the tribunal notes that recognition in international law will compensate for the damage suffered due to interference in the review proceedings. So here we have quite a different approach and interpretation to the one that Mr. Justice Foxton said was his reading at the October consequentials hearing and on which my learned friends rely. And one sees the impact of this in practical terms by reading through the remaining paragraphs in this section. Can we come to Head of Damages 1?
No challenge to Mr. Justice Foxton's reading of this, has there?
So Mr. Justice Foxton articulated this in the context of a permission to appeal application. And the reason why I'm raising this now is that we say that even though appeal on that point was given, this is open to the tribunal to reconsider as a consequence of this court's finding on jurisdiction. Indeed, if it is to be said that certain findings by Mr. Justice Foxton in October are not open to review in light of the position that the defendants now adopt in relation to them, the Czech Republic may need to reserve its rights in relation to that. But if I can just move through the rest of the paragraphs here to indicate why, in my submission, this is an important point for remission to the tribunal.
But you need to conclude within the next 5 minutes.
I'm conscious of that, my lord, yes. So Head of Damages 1 was the only one where damage was awarded. And that's described in 1033 as failure to pay for the 2008 award, as well as the costs incurred in enforcement proceedings. The reasoning that one sees there is that since the tribunal had concluded that the 2008 award is entitled to recognition in the international legal order, this means that under international law, the respondent is legally obligated by the payment obligations set out in the 2008 award. 2 points arise here. First, again, of course, I say this is affected by the trust and control point. Second, in any event, what the tribunal is doing here is saying that the 2008 award is due. That is a claim for failure to pay the 2008 award. One does not see anywhere in that paragraph a conclusion that it is awarding the sum of the 2008 award because of damage to the Czech business. It is a head of damage which arises based on a claim for compensation for failure to pay the 2008 award. What we then see in the subsequent heads of damage 2 and 3, are claims to try and recover more than what was in the 2008 award under Head of Damages 1. Head of Damages 2 for additional interest is rejected, but Head of Damages 3, to which I referred this morning, is for loss of the Czech business. The arbitral claimants were trying to recover more than the sum of the 2008 award, and the tribunal rejected that claim and dismissed Head of Damages 3, which you can see at 1036 to 1039.
The 2008 award was seen as being just and fair compensation for the loss. You can't divorce that from the fact that they've decided that it's enforceable. It's just totally artificial, Mr. Baston.
With respect, my lady, that is not what the tribunal did in the award. The tribunal did not perform an independent analysis or express a view.
They didn't need to. They didn't need to. It's inherently part of their reasoning that the 2008 award is giving the compensation that was entitled, that the parties were entitled to, no more, no less. Then it's got to be recognised in the international legal order. That's the compensation that they award. But you can't divorce them, seems to me. That's the point I'm putting to you, is that I think it's totally artificial to say, oh, well, they were doing one and not the other. They were doing both.
With respect, my lady, I appreciate that's an interpretation that has been urged by the defendants, and I understand how that interpretation arises out of these paragraphs. But as I've been picking through these paragraphs, in my submission it's clear that it is not the only interpretation. And indeed, in any event, Mr. Stava is not entitled to 100% of that amount. With respect, how can it be a finding by a tribunal that has said no issue estoppels, we're going to determine all of this afresh, for them then to say the 2008 award is fair and just confirmation for Mr. Stava, who doesn't even own 100% of the shares?
It does by then.
So by the 2008 award, correct, but in respect of the Boyar letter breach, which is what remains, that cannot be the correct outcome. So in those circumstances, oh, and pardon me, by that point as well, my Lord, Mr. Popplewell, by 2008, he does own the shares, but that is always subject to the preliminary point that I've advanced, which is that he alienated those shares in 2011, and for the reasons that we discussed this morning, he is not entitled then to claim anything in relation to that. That's the Czech Republic's position, that he's entitled to nil. However, even if one goes back to say, what is he entitled for the Boyar letter breach, it's certainly not 100%. So my respectful submission, it is a contentious reading of the damages section of this award to say the tribunal was doing both. It offered two routes to Rome, as the parties have sometimes put it in these proceedings. So given that there are those points around why the tribunal has not independently analysed the damages position caused by the Boyar letter and reached a view that this is what the proper quantification is, that in my submission militates strongly in favour of remission to the tribunal. Given that we say that there has been a jurisdictional finding by the court, which has a knock-on effect, has been the language we've used on these paragraphs of damages, and given that there are different ways of reading this award and understanding what happened in respect of the award of head of damages 1 to pay the 2008 award and the rejection of head of damages 3, calculation of loss suffered by the business, that is a level of granularity which is appropriate for the tribunal to do. It's within the parties' agreement to arbitrate. And my concluding point, if I can take the remaining 1 minute, is that what the court has heard today has been two different approaches to how to interpret this award. The Czech Republic's primary position is that it's sufficiently clear that you can vary it. The defendant's primary position is that it's sufficiently clear that it can just stand. But where the real engagement between the parties, and indeed I respectfully suggest from the bench, has been, well, what are the effects on the merits and the damages parts of the award? Given that is so, and we're at a level of granularity where we're picking through paragraphs or individual sentences in the award, and both sides are doing that, that is a clear indication in my respectful submission that remission of this issue is appropriate, rather than a shortcut, as I would respectfully suggest the defendants are urging on the court. My lords, my lady, I'm grateful.
Thank you very much. Well, we're very grateful to all of you. We will take time to consider. We will aim to produce an order with a short explanation of our reasons for whatever it is that we decide to order. And then after that, we will have submissions from you on the costs and permission to appeal if Mr. Bastin's team wants to make that application.
I'm sorry to rise again, but just on the undertaking point, we of course have not seen a draft of the undertaking. The submissions of my learned friend came at 4 p.m. or later, so I'd respectfully request an opportunity to comment on that draft when it is provided to the court.
Yes, all right. Well, Lord Verderami, you can produce whatever you're going to produce within 48 hours, I dare say.
48 hours is what we have in mind.
And then Mr. Bastin can have another 24 hours after that to make any comments on it that he wants to make. We will have to consider whether to send you judgment in draft. We won't be expecting you to agree an order in the light of it because we'll be doing that. But if we do send you a judgment, then the usual embargo will apply. Thank you all very much.